Hello, I'm Alastair Logan, and my talk today I have called "The Price of Liberty is Eternal Vigilance." And we're going to discuss the miscarriage of justice in the case of the Guildford Four. So first of all, the events. On the 5th of October 1974, the IRA planted 2 bombs in public houses in Guildford in Surrey. Guildford is a town about 45 miles southwest of London. The bombing of the pubs was designed to target young soldiers who were frequenting the pub because the beer that they sold was the cheapest in town. The first bomb detonated at about 9 p.m. and killed 5 people, 2 female soldiers, 2 male soldiers and a civilian. Approximately 60 other people suffered injuries ranging from life-threatening to minor. The second bomb exploded about half an hour later, but by that time the pubs in the town had been cleared and the injuries sustained were minor. The bombings were part of a series of attacks carried out by a small active service unit of the IRA. Most of the attacks that this unit carried out were in London, which was outside the area of the Surrey police. On the 21st of November 1974, 2 bombs exploded in public houses in Birmingham. Police arrested a number of people within hours of the bombings. The Surrey police looked ineffective in the light of that development. They therefore began combing any intelligence they could get from Northern Ireland to identify the perpetrators of the Guildford bombs. Some 50 people were arrested in early December 1974, and out of those 4 people, 3 men and a girl, made false self-incriminating statements after being subjected to physical and mental violence by the Surrey police. Their confessions were mutually inconsistent and the only evidence against them. There was no other evidence at all. Those 4 became known as the Guildford Four. My involvement started in December 1974 when I was asked by the court to act on behalf of one of what they called the bombers, and I initially refused because the case was a huge one and I was a sole practitioner. The court rang later in that day to say that no solicitor in Guildford would take the case, and as a result I agreed, and Patrick Armstrong became my client. The other 3 were represented by London solicitors. I represented all 4 for nearly 12 years after their appeal was refused. So let us look at the nature of the case against the 4, the trial, the alibis and the sentences. Patrick Armstrong and Carol Richardson had been living in derelict houses in London, being unemployed, and had survived by stealing from shops to eat. Jerry Conlon and Paul Hill were working and were living in a Catholic young men's hostel in London. Carol Richardson did not mention her alibi when she was arrested and interrogated, and her alibi surfaced as a result of the contact from someone who had been in her company that night. Police interviewed her alibi witnesses, intimidated them into varying their initial statements so as to allow a window of 52 minutes to enable the prosecution to say that Carol had bombed the pubs in Guildford and had then been driven at high speed from Guildford to London to establish her alibi. The prosecution never explained why that was not done for the other 3, or why the IRA should take such a risk and drive at high speed on a Saturday night on crowded roads. Even the prosecution's police car could not do the journey without using the blues and twos. Jerry Conlon had an alibi. His solicitors were unable to locate the witnesses, but the police had located them and had interviewed them, and then they concealed the alibi statements from Jerry Conlon and his legal team. Paul Hill had an alibi in that he was staying with his aunt and uncle, but they had been arrested and so terrified by the police and their experience that they would not come forward and refused to be interviewed. Patrick Armstrong had alibi witnesses to say he was in the derelict house at the time the bombs were planted, but his witnesses were savaged by the prosecution. All four were found guilty by a jury and sentenced to life imprisonment, with minimum terms ranging from 30 years to life means life. So now we move on to the Balcombe Street 4. Throughout the period between December 1974 and December 1975, further terrorist bombings and shootings had occurred. The bombings were forensically linked in design, method of placement and content. They were also idiosyncratically linked by the materials used in their construction, which were found in safe houses occupied by the IRA unit, located by the police firstly in February 1975 and then in December 1975. There was therefore ample evidence to show forensically that those occupying the safe houses had been responsible for all of the terrorist attacks that had occurred, including the Guildford bombings. 4 members of the IRA Active Service Unit were eventually cornered in a flat in Balcombe Street in London in December 1975, and after a siege they surrendered to the police. They became known as the Balcombe Street 4. They were interviewed and told the police that they had carried out the Guildford bombings. No further interviews took place in relation to that admission, either by the Metropolitan Police or by the Surrey Police, who later interviewed them about another offence. The police said nothing about these admissions, but the Balcombe Street 4 contacted me as the solicitor representing all of the Guildford 4, informing me that they had made these admissions. As a result, I made arrangements to interview them using a retired senior police officer and simultaneous recording. The Balcombe Street unit freely confessed to committing the Guildford bombings, providing details that could not have been known to anyone other than the perpetrators, including the identification of people who they had sat next to in the public houses whilst they were planting the bombs. Statements had in fact been obtained from these people during the police investigation, but none of them were served on the defence, so their existence was not known. The Balcombe Street 4 refused to plead to their indictment, which contained 200 counts of terrorist activity, on the grounds that they had not been charged with the Guildford bombing, which they had admitted. Joe O'Connell, the commander of the unit, made a statement from the dock in which he accused the prosecutors, police and politicians of a conspiracy to pervert the course of justice because they had deliberately left out of their trial any charge relating to the Guildford bombings. So, as a result of obtaining those statements, armed with them, the Guildford 4 appealed against their convictions. The Court of Appeal found as a fact that the Balcombe Street unit had carried out the Guildford bombings, but stated that they believed they were carried out in conjunction with the Guildford 4, despite the fact that there was no evidence to support that, and despite the fact that the role of the appeal court was not to make findings of fact, but to remit the case back for trial by another jury where new facts come to light. In the intervening years, the Guildford 4 were in a wilderness, serving indeterminate sentences with little hope of release. Considerable disquiet was expressed in this period about the safety of the convictions of the Guildford Four. Eventually, the Cardinal Archbishop of Westminster, Basil Hume, put together a deputation that included two retired and very eminent law lords, Lords Devlin and Scarman, two former Home Secretaries who had also been Northern Ireland Secretaries, Lord Jenkins and Lord Merlin Rees. They presented the new evidence to the current Home Secretary and invited him to send the case back to the Court of Appeal under his powers to do so. He failed to do that, and as a consequence, Lords Devlin and Scarman published a legal opinion in the columns of the Times, castigating the approach of the Court of Appeal and asserting that this was a miscarriage of justice which had to be put right. The Home Secretary sent the case back to the Court of Appeal shortly afterwards. The second appeal of the Guildford Four was preceded by an investigation carried out by another police force of the papers that had been retained by the Surrey police relating to the investigation. This led to the discovery of several facts which pointed to a vast conspiracy by the Surrey police and the prosecution to pervert the course of justice. Jerry Conlon's alibi evidence surfaced with a note attached to it in the handwriting of one of the Crown Counsel saying not to be revealed to the defence. Notes were found of two interviews which Paul Hill had stated under oath at his trial had taken place after he had been charged with the Guildford bombings and in contravention of the rules that permitted such interviews to take place only where the defendant was represented by a lawyer. These interviews had been denied by the police under oath. Finally, the originals of the detention sheets recording what happened at the police station to all of the four were discovered. These detention sheets showed that the evidence given by the four at their trial as to what happened to them was true, despite the denials of the police. The detention sheets that were produced at the trial were forgeries and involved no less than 32 police officers in creating them. On the 19th of October 1989, the court was hastily convened and the prosecution announced that it would not seek to defend the convictions. The Guildford Four were therefore released after nearly 15 years in prison. The court offered no apology to them for this travesty of justice. However, in February 2005, Prime Minister Tony Blair apologised to each of the Guildford Four for the miscarriage of justice they had suffered and confirmed that apology in writing to each of them. So what were the causes of this miscarriage of justice? They were physical, emotional and psychological brutality perpetrated by the police on the Guildford Four, which produced false confessions which were mutually exclusive. Concealment of evidence in relation to the alibis of the Guildford Four. Intimidation of defence alibi witnesses. Concealment of forensic and other links which demonstrated that the Balcombe Street unit had committed these offences. The issuing of instructions from the Director of Public Prosecutions via the police to forensic scientists to give false evidence at the trial of the Guildford Four and the trial of the Balcombe Street Four. Forensic scientists gave perjured evidence at two trials and at an appeal. There was concealment of the admissions of the Balcombe Street unit to the offences. There was the forgery of documents in relation to Patrick Armstrong's false confession and in relation to the detention sheets. There was perjury by police witnesses at the trial and the first appeal. and there was a conspiracy to pervert the course of justice involving the Director of Public Prosecutions, Crown Counsel, 2 police forces, the Metropolitan Police and the Surrey Police, and forensic scientists. So now I want to turn to the question of what happened to try and ensure that future miscarriages of justice didn't occur. The first piece of legislation that was enacted was the Police and Criminal Evidence Act 1985. The Act was created following the recommendations of a Royal Commission on Criminal Procedure. The aim of the Act was to establish a balance between the powers of the police in England and Wales and the rights and freedoms of the public, and it replaced nearly all of the existing powers that the police had to arrest and detain someone. The Act required the Home Secretary to issue codes of practice governing police powers. The Act also provided for the tape recording of interviews on a mandatory basis, removing the opportunity for police to manufacture a case and to attribute to suspects admissions or confessions that they had not made. Any admission or confession made outside the interview room had to be repeated so that the interviewee had an opportunity to confirm or deny on the sound recording whether he had made the admission or confession. The Act also provided for a custody suite where the rights of the detained person were entrusted to a senior police officer who had responsibility to ensure the safety and well-being of the detained person and that person's access to legal advice and the entitlement to communicate the fact of his imprisonment to a third party. However, these entitlements were not guaranteed and, by experience, were wholly absent in any case where the detained person had been arrested for a terrorist offence. The Prevention of Terrorism legislation permitted wide scope to police officers to refuse access to legal advice and to detain people incommunicado for up to 7 days. Lastly, the Police and Criminal Evidence Act empowered the court to declare inadmissible any evidence obtained in contravention of the codes of practice, and gave rise to the possibility of criminal liability if the specific terms of the Act were not complied with. The second matter that arose as a result of these events was the Royal Commission on Criminal Justice. This was set up after the release of the Guildford 4 and the Birmingham 6. Sir John May, who was instructed to carry out a public inquiry into the miscarriages of justice in the case of the Guildford 4 and an allied miscarriage of justice case of the Maguire 7, was a member of the Royal Commission. The Royal Commission was to examine the behaviour of the police and supervising officers, proper process of the prosecutors, forensic science and the role of professional witnesses, the rights of the accused to a proper defence, the range of powers of the courts in the process and whether the balance was proper, and the global efficiency of the process, including process in the right to appeal. The Royal Commission reported to Parliament in July 1993, and it recommended the establishment of an independent body to consider suspected miscarriages of justice and to refer appropriate cases to the Court of Appeal. As a result of the Criminal Appeal Act 1995, established a body called the Criminal Cases Review Commission as an executive non-departmental public body. This body is responsible for investigating alleged miscarriages of justice in England, Wales and Northern Ireland. It was established by the Criminal Appeal Act 1995 and began work on the 31st of March 1997. The Commission is the only body in its area of jurisdiction with power to send a case back to an appeals court if it concludes that there is a real possibility that the court will overturn a conviction or reduce a sentence. Since starting work in 1997, it has on average referred 33 cases a year back for appeal, and it currently receives about 1,500 applications each year. Applications are made in writing by people with criminal convictions or by their representatives. It is not necessary to have a lawyer to apply to the Commission, but around half of the applicants are assisted by a lawyer. Applications can relate to a conviction or a sentence or both. Around 85% of the Commission's referrals relate to convictions and 15% to sentences. A small handful of cases have been referred for both conviction and sentence. In 2009, the Commission's jurisdiction was extended to cover convictions and sentences arising from the court-martial or the service civilian court, covering military personnel. Andrew Ashworth, the Emeritus Professor of English Law at Oxford, has made some comments which I think are worth repeating. He said, "In recent years we have seen mounting challenge to the model of the criminal trial on the grounds that it is not cost-effective, not preventive, not necessary, not appropriate, or not effective. These challenges have led to changes in the scope of criminal law and in criminal procedure and in the nature and use of criminal trials. These changes include greater diversion, of use of fixed penalties, use of summary trials, and hybrid civil criminal processes, of strict liability, of incentives to plead guilty, and of preventative orders. Identifying the larger import of these changes draws attention to the changing relationship between the state and the citizen, as well as changes in the nature of the state itself. These in turn can be attributed to a jostling among the different manifestations of the authoritarian state, the preventative state, and the regulatory state. These changes have profound normative implications for a liberal theory of criminal law that require its re-articulation and its defence." He goes on to say, "The United Kingdom, along with other members of the Council of Europe, signed and ratified the European Convention on Human Rights some 50 years ago. The United Kingdom has gone further. The Human Rights Act 1998 requires British courts and other public authorities to act in accordance with the rights under the Convention. Yet those developments run parallel to a growing demand for greater powers to tackle serious crime. Over the last 50 years, military language has increasingly been used to emphasise the urgency of the situation. References are made to the war on drugs, the fight against organised crime, the anti-terrorist offensive, and so forth. In the last decade, there has been a distinct repressive turn in the politics of criminal justice in the United Kingdom, manifested in such policies as the restriction on the right to silence, introduced in 1994, mandatory minimum prison sentences, introduced in 1997, and harsher sentencing, which has led to an increase in the prison population of over 50% in 5 years. There is a clash between these two sets of ideologies, the promotion of human rights and the struggle against serious crime. Professor Ashworth asks, can both ideologies be pursued simultaneously without compromise? If there is to be a compromise, how should it be arranged? Should the rights of suspects and defendants be diminished, or should the struggle against serious crime be curtailed? On what basis and by whom should such decisions be taken? And if there is to be any diminution of human rights, does that mean that they are not really human rights at all? Thank you.